Good morning and welcome to today's webinar on current issues in consenting. I'm Gemma Hughes, a senior solicitor in Burness Paull's Planning and Environment team. I'm one of today's speakers and I'll be providing an overview of the consenting regime. I'm joined by my colleague Hazel Noble, who is a senior solicitor in the firm's Planning and Environment team, and she'll be providing a summary on the current issues in consenting. Firstly, a bit of housekeeping whilst you're joining. Please ensure that your mute button has been selected to limit background noise. Today's webinar won't be interactive, so please contact Hazel or myself if you have any questions. Today's webinar is being recorded, so if you have any queries around that, please check the firm's privacy policy on our website. Turning to our discussion on consenting. As mentioned earlier, I'll be providing an overview of the consenting regime. I'll do so by covering three topics. I will start by briefly comparing the various legislative frameworks for energy projects in Scotland and England. I will then primarily focus on the consenting regime for onshore generation projects in Scotland, and I will finish by highlighting legislative changes. Moving to my first topic, being a comparison of the legislative frameworks for energy consenting. In Scotland, there are two consenting regimes for energy projects. A project's capacity will dictate which regime is engaged. The first is found in the Town and Country Planning Scotland Act 1997. In this consenting regime, permission is granted by the local planning authority. The second consenting regime is contained in Section 36 of the Electricity Act 1989, in which consent is granted by the Scottish Ministers. It's also worth highlighting that the Scottish Ministers can grant transmission consent under the Electricity Act as well, but that's under Section 37 of that. In comparison, down in England, there's a similar two-part divide across the Town and Country Planning Act 1990 and the Planning Act 2008, which provides the legislative basis for national significant projects which require development consent orders. Given the length of today's webinar, I will focus on developing projects in Scotland, although the team does have wider experience. Moving to my next slide, this outlines the various Scottish consents. As alluded to earlier, the capacity determines which consenting regime a project falls into. When it comes to capacities, it is the nameplate capacity of the scheme that counts. So if the project has a capacity of 50 megawatts or under, then an application is made to the local planning authority under the 1997 Act. If the project has a capacity of over 50 megawatts, an application is made under Section 36 of the Electricity Act to the Energy Consent Unit of the Scottish Government. At the same time as submitting a Section 36 application, developers will usually apply for deemed planning permission, which is granted alongside a Section 36 consent. In terms of specific technologies, wind and solar tend to be relatively straightforward in terms of the regime applying, particularly if they are just standalone. For energy storage projects, Scottish Government treats battery generation projects as generation projects, and the same 50 megawatt generation threshold applies for batteries. This is notably different from England, where they always come under the Town and Country Planning regime, with an application being made to the local planning authority. Additional planning permissions or use of permitted development rights may also be required for other infrastructure that isn't part of the main application, so it's also something to be aware of. Other regulatory regimes may also apply. For example, the scheme may require a generation licence from Ofgem. There could be a requirement for car licenses, or a project could require European protected species licenses. For offshore generation projects, the application would be made to the Marine Directorate, not the local planning authority or energy consents. And marine licenses would also be required in addition to Section 36 consent. For offshore projects, developers would also need consents to extinguish navigation rights or establish safety zones around offshore infrastructure. And planning permission would also be needed for the accompanying onshore infrastructure. For hydrogen, this is not considered as generation by the Scottish Government, and the application as it stands, would always be made to the local planning authority for planning permission under the 1997 Act, regardless the size of the project. Hydrogen will usually require a hazardous substance consent on top of planning permission and would also need to comply with the control of major accident hazard regulations. So moving to my next slide, as discussed, onshore we have two main systems in Scotland. The first of those is for projects 50 megawatts and under. For these, developers must submit an application to the local planning authority. As mentioned, this would be under the 1997 Act. Projects which are 20 megawatts or under are considered as local development. Projects between 20 megawatts or up to 50 megawatts would be considered as major developments. The slide here sets out an overview of the process for major developments, as this is the type of projects we normally see at this local planning authority level. In terms of process, firstly, the applicant seeking planning permission will have to undertake design and survey work. Energy project developers will usually need to carry out statutory pre-application consultations. Pre-app consultations will involve holding public events and will seek to inform the community about the proposal and give them the opportunity to contribute their views prior to the submission of an application. If the proposal is likely to have significant impacts on the environment, then the applicant will also be required to go through the environmental impact assessment process, which is a process where the likely significant effects on the environment are systematically set out and considered as part of the decision making on the project. The applicant can go through a screening process to determine whether an EIA is required if it's not clear whether the project is EIA or not. If the project is an EIA development, the applicant can go through the scoping process, which will set out the parameters of the required EIA. Following the pre-application consultation and preparation of the application material, including an EIA if needed, that the applicant can submit their application to the local planning authority. For major developments, a local planning authority has 4 months to determine the application, and this will often involve an application going to committee. For local developments, the local authority has 2 months to decide. The local authority can make one of 3 decisions. They can grant the application with or without conditions attached. They can refuse an application, or the authority can be minded to grant the application on the condition of entering into a planning agreement. A decision of the local authority can be appealed by the applicant if it's a local application to the local review body, or if it's a major application to the Scottish Ministers. Any appeal decision is final, and the only route, if you want to challenge that decision, would be a statutory appeal to the Court of Session on a point of law. Moving to my next slide on the process for projects over 50 megawatts. As discussed, this is different. Consent would be required under Section 36 of the Electricity Act, and deemed planning permission could be applied for under Section 57, paragraph 2 of the 1997 Act. The application is submitted to the Energy Consents Unit of the Scottish Government, and the Scottish Ministers are the ultimate decision makers. The planning authority will also be involved in this process, but this time only as a statutory consultee. The applicant will first have to undertake extensive design and survey work before engaging in the formal planning process. Once it is ready, the applicant will have pre-application discussions with Energy Consents. Whilst pre-application consultation and engagement are not currently mandatory under Section 36 applications, there is a general expectation that applicants will engage in this as part of the process. Most renewable energy projects of this scale will be EIA development, and the applicant will normally go through EIA scoping and prepare an EIA. Following consultation and drafting of the EIA, the application will be submitted to Energy Consents. Energy Consents will then notify any interested party about the application, including statutory consultees such as the Local Planning Authority, Nature Scot and SEPA. The consultees will then have the opportunity to consider the application and decide whether to object or not. Where an objection is raised by the local authority, this currently automatically triggers a public inquiry. Energy Consents will then transfer the case to the Planning and Environmental Appeals Division of the Scottish Government, who will appoint a reporter and hold an inquiry. The key topics will be analysed in a series of ways, including inquiry sessions, which involve witnesses and leading evidence, hearing sessions and written submissions. There will normally be sessions on planning and energy policy and conditions to be attached should any consent be granted. Following the conclusion of the inquiry, the reporter will write a report making a recommendation to the Scottish Ministers. This is not binding, but is usually followed in the final decision. The Scottish Ministers will take and issue the final decision on Section 36 applications. This will be either to grant the application or refuse consent. This applies regardless of whether an inquiry has been held or not. Their decision is final, although subject to legal challenge. And notably, there's no statutory timescales for determining a Section 36 application. So as we can see, there have been a few differences between the frameworks. In Scotland, there are no statutory determination timescales for large-scale energy projects, whereas smaller scale projects do have determination deadlines for decision makers. Policies do hold a different status under the two frameworks as well. So for smaller scale developments, the development plan, which is made up of the local development plan and National Planning Framework 4, has primacy for decision makers, whereas for larger scale projects, the development plan does not have primacy, although it is a relevant consideration for decision makers. As discussed, there are different decision makers engaged. So smaller scale developments are determined by local planning authorities. So there's a right of appeal to the Scottish Ministers, whereas larger scale developments are determined by the Scottish Ministers. So there's no right of appeal. But both types of developments can be legally challenged at the Court of Session after they have reached the final decision on a point of law only. Moving to my last topic, which is legislative changes in Scotland. So the Town and Country Planning Scotland Act 1997, which I've mentioned quite a few times, has been greatly amended by the Planning Scotland Act 2019. This is still very much settling, so something to be aware of. Only on Monday, new fee regulations were laid before the Scottish Parliament. The regulations will come into force on 9th of June and, amongst other things, introduce fees for planning appeals. The amounts are significant, so worth reviewing if you're considering an appeal. For example, a wind farm over 3 turbines, the fee is going to be £238 per 0.1 hectares of site area, and the max appeal fee has been capped at £71,424, so definitely worth having a look at if you're considering an appeal. As highlighted in our February webinar, the Planning Infrastructure Bill is proposing to greatly amend the Electricity Act 1989. On March 10th, the Scottish Government and the UK governments published their response to the Electricity Infrastructure Consenting Scotland consultation, and the bill was introduced to Parliament on 11th March, and is now at committee stage. Notably, the bill includes enabling powers for the Scottish Ministers to create regulations on the requirements for applications, including the information that should be included in the application, and introduce pre-application consultation requirements similar to those found in the 1997 Act. The bill also introduces enabling powers for the Scottish Ministers to create regulations that will introduce time limits at various stages of the application process, including time limits on the reporter to take steps where there is a local planning authority objection, and importantly, on decision making by the Scottish Ministers. The automatic requirement for a public inquiry where the local planning authority objects is being proposed to be removed, but the Scottish Government have confirmed they'll publish guidance on this. We will be monitoring this bill closely as it progresses further through Parliament, so please look out for our further updates on this. I'll now pass over to my colleague Hazel, who will be discussing other consenting issues to watch.
Thanks, Gemma. Moving on now, I'm going to consider some current issues impacting renewable energy project consents in Scotland and the UK. Firstly, I want to talk about policy and guidance. To set the background, policy and guidance in this field is constantly evolving. As advisors, this keeps us busy and engaged. The backdrop of climate change and the need for energy security means that there has never been more pressure than now to accelerate the transition to renewable energy sources. The Scottish Government and the UK Government have a heavy focus on energy. The Planning and Infrastructure Bill includes a number of measures designed to overhaul the planning process. We've seen early commitments to this translate into policy, with the government's Clean Power 2030 Action Plan published at the end of last year. And just last Thursday, the UK Government opened a consultation on the new draft National Policy Statements for Energy. In Scotland, we've recently had NPF4, the National Planning Framework for Scotland, with numerous policies relevant to renewables, and have seen both grants and refusals of large-scale energy proposals since then. The big energy policy document we've been waiting for some time now is the final Energy Strategy and Just Transition Plan. This will set the key energy policy for Scotland when it is published. There are simply too many developments to cover in this webinar alone. However, we have handpicked a few recent policy developments which we consider to be of note and which I will deal with now in more detail. The first is biodiversity net gain and enhancement. This has been a hot topic in the past year. Biodiversity net gain is an approach to development that leaves biodiversity in a better state than before and requires developers to incorporate this into planning proposals. In England, it is now mandatory for a minimum 10% uplift in biodiversity to be delivered on all non-exempt development as of last year. In Scotland, NPF4 Policy 3 introduced a new requirement for biodiversity enhancement, although it is important to note that Scotland's policy-led approach is designed to be less rigid than England's. Looking ahead, and the Scottish Government has appointed NatureScot to develop a Scottish-specific biodiversity net gain metric. Developers will be able to use this to calculate and evidence the extent of the enhancement measures. There are no published timescales on this work. However, the Scottish Government has confirmed that the absence of an established metric should not delay decision-making meantime, and a flexible approach will be required. Lastly, on biodiversity, the National Environment Scotland Bill has now been laid before the Scottish Parliament. If approved, it would place a duty on ministers to set legally binding nature restoration targets. We expect to hear more on this later in the year. The second hot topic I want to speak about today is community benefits. In recent months, we have seen an increased emphasis on the economic impacts of renewables projects, particularly in Scotland, where NPF4 Policy 11 includes a test that any new renewable energy development proposals should maximise net economic impacts. For many years now, it has been practice for onshore wind developments to contribute per year to a community benefits package. At the end of 2024, we received clarity that community benefits remain a voluntary arrangement and sit outside the consenting systems for onshore renewables. In other words, they are not a deciding factor in the planning process. Nonetheless, Policy 11 continues to be a concern for developers. Recently, the absence of guidance has resulted in some councils, most notably Highland, to adopt a position on what they would be looking for in terms of local economic benefits. Highland Council has proposed that, in addition to investors paying £5,000 per megawatts per annum to direct community benefit funding, investors will also contribute a further £7,500 per megawatt per annum to a central fund. This central fund is intended to support economic development, increase prosperity, and achieve equity for communities across Highland. For developers, this presents a very steep increase in development costs that may well go to the viability of projects. Direct discussions are ongoing between industry and the Highland Council to try to reach a way forward. Meanwhile, Scottish Renewables have produced a maximising economic benefit framework, which they are encouraging developers to use to demonstrate compliance with Policy 11 when dealing with local authorities. The Scottish Government is continuing to review its guidance on community benefits. In December last year, it launched a consultation to review the good practice principles for onshore and offshore renewable energy, with the aim to enhance community benefits provided by developers. The feedback from this is intended to inform a refresh of the good practice principles in late 2025, and it is hoped that this will bring clarity for developers going forward. Lastly, we have seen and are likely to continue to see shifts in the types of renewable energy projects gaining traction in consenting. Perhaps the most notable shift came in England last year, when the UK government took the decision to lift the policy, effectively banning onshore wind. The decision reversed a policy that had been in place since 2015 and is part of the government's plan to double onshore wind energy capacity by 2030. Meanwhile, new technologies are coming to the forefront. On 7th of April, the UK government shortlisted a new wave of 27 hydrogen projects, the second wave in projects earmarked by the government. The projects stretch across the UK and include the Cromarty Hydrogen Project in North East Scotland. Moving away now from the policy side of things, I want to deal with briefly some practical issues, which we are seeing more commonly as lawyers dealing with these projects at an early stage. The first is resourcing and upskilling. In planning, this has been an issue in Scotland now for many years. However, now that there are more large-scale energy applications than ever and they are more complex, the issue is becoming more acute. Scottish Government has been looking at this over a period of years and has floated a number of ideas. The Energy Consents Unit has finally managed to get funding to up staff, and by the end of Q1 this year, they should have recruited more than double their previous staff numbers. In September, Scottish Government announced the introduction of the National Planning Improvement Hub. The Hub's initial priority will be to help planning authorities make quicker decisions on hydrogen planning applications, but the plan is to extend the services to support wider developments, including renewables. It's worth noting that in England, planning authorities are facing similar issues, and the UK government has recently announced a £46 million package of investment to tackle problems with capacity and capability. Secondly, a significant current issue for onshore wind especially is oversale. Onshore turbine components are much larger than they used to be as technology has moved on. Therefore, when turbines are being transported to site, the components are passing over private landowners' land, and this requires rights. A number of landowners are requesting very high sums, and particularly in cases where there are multiple landowners involved, this is becoming a real financial issue for projects. This also includes repowering projects, where roads were previously able to accommodate smaller turbine components, but now as sites are repowered with larger turbines, oversale becomes a new project issue. The Scottish Government's original idea was to produce guidance, including benchmarking for contractual negotiations, but data collected was too varied to provide benchmarks. The Government is now working with those involved in land deals to determine trends and models used in industry. Compulsory rights specific to oversale was not something consulted on in the Electricity Act consultation, and this does remain an issue. Industry is of the view that there should be another consultation to address this in Electricity Act amendments. Lastly, one thing that we are seeing more commonly as lawyers to get involved at the early stages of these projects is more than one type of technology. This could be wind and battery, solar and battery, or all three, all at one site. The project can be designed this way from the outset, or alternatively, other technologies, for example, batteries, can be added to existing schemes. The key, of course, is to ensure that you obtain the correct consent for what you are proposing, and that you also fully assess the environmental impacts of what is being proposed. Consideration should be given to whether the project technologies will be split out and operated by different entities. The operator of the asset will need to have the benefit of the relevant consent. This is particularly relevant for Section 36 consents, which are personal. In summary, the landscape against which consenting is taking place and the expectations on developers are constantly evolving, and the speed of change is fast. As advisors, our job is to keep abreast of this changing sector landscape and advise our clients on the best way to navigate it. That concludes our whistle-stop tour of consenting issues. If you'd like to take a deeper dive into some of the other aspects of energy projects, our Junior Energy in-house webinar series has a number of further sessions upcoming. On 20th of May, our corporate finance team will be discussing the National Security and Investment Act 2021, where they will provide an overview of the impact of the Act on renewable energy transactions. As discussed, our session today has been recorded, and you will shortly receive an email for a link to the recording of the session. In that email, you will also find a link to register to further sessions and learn more about the programme. Please do use the link to check out these upcoming sessions and book your spots in advance. In the meantime, if you'd like to hear more about any of the topics covered today, or if you have any specific queries for us, please do reach out to one of the team. Thank you very much for joining today's webinar, and we look forward to seeing you at our future sessions.